lectures on the legacy of the Nuremberg trials. As Greg Peterson said, I'm a law professor, I am a fellow at the Jackson Center, and I am Justice Jackson's biographer. I came into the topic of Nuremberg as a former prosecutor and as a law professor working on the U.S. Supreme Court and finding that in the history of the court and its 109 justices, a huge figure, perhaps the biggest of modern figures, was someone whose legacy had plenty of room for more study and whose stock was sort of exploding in value. This is 8-10 years ago when I was first beginning to work on Jackson. As I worked on Jackson, I had a lawyer's and a layperson's knowledge that he had gone to Nuremberg as the chief prosecutor, and that made him a category of one. There's no other Supreme Court justice who's ever taken on a collateral task like Jackson's work at Nuremberg. And although I was not steeped in international law and my prosecuting experience was entirely domestic, I found that that topic is at the top of the list in understanding not just the significance of Robert Jackson, but the significance of law in the 20th century. And so that has become a centerpiece of my project. It's the focus of the book that I'm in the process of completing. And I think it is one of the events that, as one learns more about it, becomes in common understanding a legal, historical, political, and human development on a scale that few others rival. In the legal realm, there is, of course, Constitution Hall in Philadelphia, and the framers during that hot summer of 1787, writing a document to try and empower a national government that could function in a way that the Articles of Confederation hadn't. And there was legal reformation following the U.S. Civil War in the framing and ratification through military occupation and not much voluntary decision-making by the southern states of the 13th and 14th and 15th Amendments that changed the fundamental creed of this country to equality. There have been, in the international realm, events that I think are permanent and are high order and are significant. The United Nations, following World War II, is certainly one on that list, and the conventions that are part of that process. That spectrum of activities is actually in the wake of Nuremberg. So what I want to begin with in this lecture, which will have 3 parts, is a first phase that begins actually with war. I'll have Robert Jackson over my shoulder, but I want to talk about World War II and talk about the world situation. What I'm going to do in this framework is have this introductory segment that gets us from war to victory to a commitment to the trial process and through the summer of 1945. That'll be part 1. Part 2 will be the international trial that commenced at Nuremberg in the fall of 1945 and carried through the next year, through September of 1946. Part 3 will be the subsequent Nuremberg and other proceedings that continued in its wake, in its tradition, and standing on its shoulders to prosecute criminality, and the legacy of those events in history and law up to the present world of international law. Each of these segments will be about 15 minutes, and what I propose to do is to pause for questions and a little dialogue at the end of each segment, because these are really shared topics. These aren't specialist topics. These are common humanity topics, and you as Chautauquans, which is a special word that in a way to knowledgeable insiders conveys deep intellectual engagement, and as special students, I guess formally here, are part of this study. And so I want there to be plenty of time for your questions. Part 1, war to trial. My speech disappeared. Somebody move a yellow pad? We'll call that another technical difficulty. Greg, you took it. It's under your pile. Nothing like an intro man who sabotages the speaker, right?
While he's setting up, you can also go to the bookstore and get his book entitled That Man, which I forgot to mention. That's why I took your speech.
You've got more stuff, which I need that. Part 1, war to trial.
Maybe the mic's
doesn't work. It's just a light. It's an attractive red light that performs no amplification function. World War II started in Germany. It was a conquering by the Nazi Party of its own country. It is a process of emergency powers and the abdication and surrender of a democratic process to a minority splinter party. It is internal terrorism. It is party putsches. It is a opportunistic merging of left-right ideology. This is National Socialism on the left, but not at the communist fringe, becoming authoritarian, totalitarian, militaristic, and oppressive. Adolf Hitler, in 1933, assuming the powers of president and chancellor, is a head of state at a moment when you should recognize the world condition. Deep global economic depression. And the political turmoil, the desperation, the fragility that conveys. Consider alternatives that are literally on-spot contemporaries of Hitler coming to power in 1933. That's when Joseph Stalin becomes premier, heading the Russian Communist Party in the USSR. That's when Franklin Roosevelt takes the oath of office in March of 1933. Mussolini, 10 years earlier, has been a fascist and popular and successful national leader. But Hitler and the Nazis first conquered Germany. And I call it the start of the war because the methods soon come to include the brutality, the rights violation, the oppression, even the physical punishment and extermination that characterizes warfare. Not on an enormous scale. Concentration camps, for one who studies media reports from the time, are innocent words, concentration camp in a sense, because it's a synonym for prison, for incarceration, for detention. And of course, enemies of the state, criminals, undesirables, every country's got them and has processes for identifying them and then confining them, concentrating them. That's an understanding that the world has when it's not paying close attention. Robert Jackson, as a senior Treasury Department official, working on a massive international litigation, travels to Europe in 1935. His work is in Sweden. His side junkets include a trip to Berlin. He stays at the Adlon in the shadow of the Brandenburg Gate. He has a day and a half down the block from the Reichschancellery. His records from the time, notes and correspondence show that he was struck by the economic desperation, by the visible military and police presence, and by the seeming control of public unrest that the Nazi government was achieving, with no mention of incarcerations, Nuremberg laws, dispossession of Jews, professional outlawings, and so forth that were in process at the moment. And this is a sophisticate on-the-ground perspective. In 1938, German expansion literally begins across borders. And the war waging, you know the story, the Sudetenland, the Low Countries, the Anschluss, Austria, into Poland in 39, the so-called phony war through that winter, the attack on France, its quick collapse, its surrender in June of 1940, and England alone by the summer of 1940 against a Nazi expansion and aggression that has conquered the European continent. Our country in that period is far away, relatively secure thanks to the large ocean that separated us from this power, extremely isolationist politically, hostile to immigration, quotas defining our politics, pacifism defining our defense structure, rot and decay being what's happened to our military stock since World War I, and anti-immigrant in a way that was also job protective and connected to the Depression. If you open borders and you take in refugees, of course you're bringing in competing labor at a time when there is job scarcity. Franklin Roosevelt and his inner circle of advisors come to understand in the late 1930s what Hitler presents as a threat to Western democracy, primarily and immediately to our ally Great Britain, but potentially across the Atlantic to us as well. And what Roosevelt is navigating with this inner circle that includes his Solicitor General, who becomes, in 1940, his Attorney General, is the move of a country from unpreparedness and isolation, disinterest maybe even a fair word, to preparation, to support, to engagement, and to a commitment eventually to respond to attack. Not to be an aggressor, but to be a defender. He's also doing this, recognize, as he's running for an unprecedented third term. The politics of that is trickier than anything we've seen in our recent lifetimes, and somehow he navigates this. This is Roosevelt in May of 1940 addressing a joint session of Congress. You can't read the small caption, but he's asking for $1 billion, which in 1940 is real money, to build up United States air defenses. Of course, one way to build up air defenses is to build planes, and one thing you can do with planes is give them to other people. And clearly the concept is that these won't all be based on territorial Mother United States, but this could be British Royal Air Force reinforcement. You'll notice, and excuse my finger, some of the significant people and some of the much less significant people who are here in the joint session of Congress. President Roosevelt, of course, is on the dais. You see here arrayed in a semicircle the cabinet. This is Harry Hopkins, the Secretary of Commerce, who's perhaps the most important personal advisor to Roosevelt at the moment. This is Robert H. Jackson, the Attorney General of the United States. This is Senator Harry Truman from Missouri. Nice guy, bright guy, machine pal, popular guy, and destined for nothing great. You know, Missouri, and that was where it was going to stop. He has worked his way through seniority and regional politics, and remember this is an election year, up to the front row, but this is the Senate seating. This is the executive branch player seating. And I focus on Harry Truman because, of course, he is one of the heroes of the Nuremberg story. This legislation is passed. A national emergency is declared in terms of military preparedness. A deal is worked out with legal advising from Robert Jackson over that summer of 1940 to provide overaged, mothballed World War I era destroyers to Great Britain in exchange for leases on British bases throughout the North Atlantic down through the Caribbean. A steal, basically, is what it was in terms of actual value. We're giving old clunkers and we're getting real estate. Good national defense protective real estate. And that's what made it legal, and that's what made it popular. That was a Jackson legal project. The rationale in this time period of defense buildup and of destroyer deal, of the commencement of selective service, which is enacted by the Congress by one vote in the House in September of 1940, and then going forward into the March 1941 period after the election, the Lend-Lease Project, which by legislation greatly expands what we're doing for Great Britain on a loan basis, and then in time, once the German-Soviet alliance fractures with the Russian attack, it becomes Lend-Lease to the Soviet Union, is legislation, politics, and legal work premised on a core theory of illegality. What the Nazis have done in assuming undemocratic power, in seizing their own country, and then in waging aggressive war across the continent and then across the channel through the Blitz on Great Britain, was a crime against international law. That theory, that 1940-41 theory, which is the political argument, which is the success of Roosevelt and his cabinet, including Jackson, in moving our country from nowhere to somewhere in terms of military preparedness, is the theory of Nuremberg. That war is a crime. Not a defensive war, not a self-protective war, but the waging of an aggressive war, the attacker, the unjustified expansionist seizing of power is a crime, and always has been. Now that is a broad, broad claim. We'll come back to this near the end of this segment when I'm telling you about the summer of 1945. But I want you to see the roots of it in this late New Deal, second term, early third term period. We are preparing for Germany. We are preparing for its ally, Italy. we are not preparing for Japan or a war coming from the east in the Pacific theater. And thus, Pearl Harbor on that Sunday morning, learned in Washington that Sunday afternoon, is a huge shock at every level. Obviously, America attacked as a general shock. But America attacked from the other side in a place where we weren't preparing and we didn't want to wage a war, is the executive branch problem. And the declaration of war that Roosevelt seeks the next morning at Congress is, of course, a war against Imperial Japan. The European theater probably would have been abandoned, at least greatly neglected after Pearl Harbor, but for one amazing piece of luck, and I do say that a little bit with my tongue in cheek. Adolf Hitler later that week declares war on us. Democracy and human rights should thank some big power for that colossal idiocy. Of course, it created a horrible war, and tens of millions of people died. But without Allied involvement in the way that responded to that declaration of war, more than those tens of millions would have died. And the Holocaust would have been a fully accomplished project, for instance. But we got in. We got in slowly. It required a huge, as you know, some of you were probably very young at the time and have memories. Others of you have studied. It required a huge mobilization, a huge buildup. It is a response to aggression, physical and declared aggression. By 42, North Africa. By 43, Italy. By 44, summer of 44, again an election year. Talk about rolling the dice in a big political sense. Normandy. We're fighting, and gradually we're winning. In 42 through the middle of 43, it's very interesting to study this period because there is no confidence in the private councils of our leadership that we will prevail in that war. It's up for grabs until the middle of 43. Eventually, however, it becomes clear, and it really is the Soviet Union here that deserves primary credit, because Hitler, by, again, a foolish decision, deciding to attack his ally and go east, picked a fight he couldn't win. The numbers and the determination and the toll paid by Soviet citizenry in that fighting won World War II in the European theater. And that allows us to see the coming victory. The project at the top level, this is Stalin, Churchill, and Roosevelt, includes all the tactical and political and diplomatic aspects of waging this war that they're now winning. But it also comes to include, beginning with very general rhetoric in 43, with more developed statements in 44, and with a commitment that's part of the Yalta Decree in February of 1945, a commitment after the victory to prosecute Nazi war criminals. The theory was that this wasn't just an exercise of power, but that there was something legally prescribed in what the Germans had done, and thus, once they were defeated, individuals should be held accountable. Enter the cabinet officers beneath Roosevelt. During this period, that is a debated proposition, intensely debated. And the polar positions are represented, ironically, by Secretary of Treasury Henry Morgenthau on behalf of brutal power versus Secretary of War Henry Stimson in favor of restraint and law. The Morgenthau proposal and the Morgenthau plan is that Germany should be forevermore reduced to a non-threat. Twice in 30 years it has thrown the European continent into this cataclysm of war, this toll of death and destruction, says Morgenthau. And we, the fighting and victorious opponents of this aggression, should prevent it from ever happening again. The view is frankly a reductionist, intrinsic view of evil in Germany, and it connects it to the industrial and economic power of Germany. And so Morgenthau proposes to strip the country of industrial assets, to reduce it permanently to an agrarian peasant society, herding animals, harmless, but no manufacture, no machinery, no metals, no furnaces. That will be Germany, and thus Germany won't bother anybody. And the people who survive, who are the madmen of the Third Reich, should be shot. The Morgenthau Plan, as it came to be called, never gets to the level of particular numbers that execution, summary judgment, executive action strategy really contemplates. But it is some considerable number. And the Morgenthau argument has allies. One is Winston Churchill. He's got a much smaller number in mind, but a couple of hundred Germans at the end of the war should be lined up somewhere and never heard from again. Joseph Stalin jokes at one of the Roosevelt-Churchill-Stalin meetings that it should probably be about 50,000 Germans who should be executed. And Roosevelt, I think, to sort of diffuse the awkwardness, jokes, well, 49.5 probably will be sufficient. But think of this path that's being, from a jocular discussion through serious levels of policy debate down in the cabinet. Think of this path and what it would have been if we had taken it. How we would think of ourselves if that is what we, the Allies, had done following our victory. Whose methods would we have been emulating? What legacy would we have been creating? What notion of human rights versus power would we have been cementing into our national identity forever? The other side of the argument is Henry Stimson. Henry Stimson, a great lawyer, a Republican brought into the cabinet by Roosevelt during this preparation period of 40-41, Secretary of War here, previously Secretary of State, a grand leading figure of the American bar, is a believer, of course, in warfare to defend, to protect, to respond to aggression, but more fundamentally is a believer in law. And what he argues against Morgenthau, and it is a pitched battle, and at various times Roosevelt seems to be saying yes to each. What he argues is that the Morgenthau plan, brutal action, is not appropriate. Instead, what we can do is, in some lawful proceeding, bring charges, marshal evidence, present a case, and determine culpability, and punish, the way we do any other crime, this criminality, this waging of aggressive war. Franklin Roosevelt is, at the end, in a very general way, persuaded, and his decision is in Stimson's favor on the law path. That brings me back to Robert Jackson. This is him working, probably in a posed photograph, at his desk in the Attorney General's private office during this 1940-41 period before he goes to the Supreme Court. He is, during the war years, a Supreme Court justice, but before that had risen up through the executive branch, and before that had risen up through the private practice of law in this country to be one of the leading lawyers ever. A skilled advocate, both in trial and on appeals. A beautiful writer, a sophisticated, experienced negotiator. As a policy experience, somebody who had been involved in all the legal work of war preparation during 38, 39, 40, 41, through the Justice Department work that he did. And thus, as the war is being won, and the question of who should be the U.S. representative to chart this law path to prosecute war criminals, Jackson's is the name that rises to the top of the list. This is Jackson working with his Solicitor General, Francis Biddle, the number 2 figure in the Justice Department, a close friend during those 40-41 years. Biddle will recur in our story. The decision-making to recruit Jackson is in process when Roosevelt dies on April 12, 1945. And thus Harry Truman, off on the side seats, formerly a senator from Missouri, a somewhat machine deference pick by Roosevelt to be his running mate in 1944. It was mostly about replacing Henry Wallace and keeping organized democratic machines, including the Prendergast machine in Missouri, happy. And then an accidental president of the United States is at the helm. He's hugely unprepared. You know the story generally of the Manhattan Project, unknown to him till it's briefed to him in his first days as president. Also, this question of what to do with Germany is unknown to him, unstudied by him, briefed to him in those days. And he's told the decision is war, not power, trials, not summary executions, and the person we want is Jackson. Truman thinks the world of Jackson. Jackson had provided key personnel to aid the Truman Committee, which really elevated Truman's reputation during 42, 43, 44, looking at defense production ripoffs and contract frauds. And they had a personal, more than an acquaintance, I would call it a medium friendship. And Harry Truman, insecure, knows that Robert Jackson is one of those national figures who by all rights probably should be at the desk that Harry Truman, through circumstances, now occupies. He privately told many people during this time period that there was really only one Democrat who was presidential timber, and it wasn't him, it was Jackson, who was on the court, and then at Nuremberg, and then back on the court. Truman, through Sam Rosenman, legal advisor, White House counsel, who he inherits and retains from Roosevelt, makes the appeal to Jackson. And I want you to focus on the timeline, because it gives us, looking forward, a sense of what this job really was at the time Jackson takes it on. We look at Nuremberg from the back end. It looks orderly, it looks accomplished, it looks completed. They lived Nuremberg from the front end. This is before they knew about Nuremberg as the location or the defendants or how it was going to go. Roosevelt dies on April 12th, and Truman takes the oath. Rosenman is in communication with Jackson within 10 days. Jackson is speaking to Truman and negotiating, defining, and then accepting this offer on April 26. It's finalized on April 27. The executive order is April 28. It's not announced publicly until May 2nd. One more date. Adolf Hitler lives until April 30th. The job that Robert Jackson takes, the prosecution that he is willing to handle through lawful processes on the world stage, is the trial of Adolf Hitler, should he live. And the immediate circle of senior advisors who are part of perpetrating this aggressive war: Goebbels, Himmler, Goering, a handful around Hitler. And within days, of course, most of them leave the scene. Now you ask, how does a Supreme Court justice sort of sign on for an extracurricular job like this? Well, Robert Jackson, known for his beautiful writing, was also a ferocious worker and a brisk writer. And he had finished writing his opinions for the Supreme Court term at that April moment. The court didn't recess until mid-June, but Jackson was largely done and waiting for his colleagues. And he believed that the representations were to be trusted, that there were cases ready to go, that evidence had been gathered, that the Allies had worked out across these Yalta and predecessor meetings how this was going to happen. Within days, Hitler's dead, Jackson's on the job, there's no case assembled, there's no evidence assembled, there's not even an agreement among the Allies. Instead, there's something like this. It's much too small for you to see, but I think you can see the lines. It's an organization chart of German power that's given to Jackson in the first days of this project by War Department experts. Jackson almost pulls his hair out, and he was losing it, so it would have been a little bit risky at the time, but he looks at this: 1,000, 5,000, 26,000, 28,000, 89,000, 463,000. NSDAP leaders, the Nazi Party, 1.04 million people. Members, 5 million. Voters, 48 million. German citizens, 79 million. Jackson's job is to prosecute the criminals. He thought he could be done with this task and back on the bench by the first Monday in October, 1945. He was wrong. He was away from the Supreme Court. He was AWOL for an entire year. It wasn't as jarringly uncommon as it seems to us for a Supreme Court justice in those days to take on a collateral task. The most recent one we know of is Earl Warren heading the Warren Commission after the murder of President Kennedy. But after Pearl Harbor, Justice Roberts headed an investigative commission. Chief Justice Stone did various collateral tasks. Their sense of separation of powers was not as strict as ours. But no justice had ever done anything like this. And interestingly, at the end of this year, where Jackson's absence was controversial, including for his 8 colleagues who were carrying the work of 9, and in many cases dividing 4 to 4, somewhat unpopular. The American Bar Association, at its convention following Jackson's year of absence, promulgates a resolution that Supreme Court justices should not take on extracurricular tasks. And the key speaker at the ABA meeting urging them to ratify this is Robert Jackson. During his absence, he tried repeatedly to resign. The court needed 9, he told President Truman. He needed to finish this job, he told President Truman. He couldn't commute back and parachute in and hear re-argument in the 4-4 cases, he told Truman. And Truman, every time throughout that year, told him, stay put. The law is the law is the law. You'll finish this law, you'll go back to that law, and I want you on this court. And so Jackson did stay. But first he had to do this. It happened in London during the summer of 1945 that the Allies worked out how they were going to proceed. And the US and Great Britain were largely aligned in legal systems, in philosophy and diplomacy, in the shared understanding of what a trial process would entail. The Soviet sense of a trial was vastly different. The Soviet negotiators believed that this commitment to trial was a decision to have a trial of the Germans who would be shot. And thus, let's of course plan this trial. A big courtroom will be good, lots of media, and then the firing squads. The French were largely decorative. They're the fourth nation in this process, but it was a new republic and they were the weakest participant in the process. Over the summer of 1945, negotiating in Church House next to Westminster on the grounds of Westminster Abbey, Jackson, on one side of a large four-sided table, hammers out an agreement to create an international court, to define crimes that this court will have jurisdiction to adjudicate, to have resources that will be provided to the defendants, including counsel of choice, including discovery of documents, to proceed in public, to have evidentiary standards, to rule as relevant some matters, and to rule out some things like following orders, for instance. That takes 7 weeks. It takes a lot of hard negotiating, and it frankly takes an impasse. Jackson flies from London to Potsdam, outside of Berlin, in late July 1945. That's where Truman is meeting with Churchill, and then when he loses the election, he's replaced by Attlee and Stevens and Stalin. And one of the things that they are working out is this war criminals commitment that had been made at Yalta and at Moscow and in the other declarations. And Jackson says, we're at an impasse. If my instructions are to make it work and hold together this agreement with the Russians, I'll capitulate. If my instructions are to stick to what I think are fair legal processes, the Russians may walk. I'll at least threaten that. They also may blink. And Jackson is told by Truman, by Jim Burns, the Secretary of State, by John McCloy, the Assistant Secretary of War, etc., hey, Bob, you're the United States. Whatever you think is right. Quite an amazingly free leash that Jackson had. And he comes back and plays his cards very aggressively, causing the Russians to blink. It helped that the Americans had in their custody most of the principal surviving Nazis, who were the likely lead defendants. And thus, on August 8, 1945, the four nations conclude an agreement, creating the International Military Tribunal, defining Berlin as its seat, defining 4 crimes as within its jurisdiction, and moving in the direction of trial. Those crimes are the waging of aggressive war, the theory of our defense buildup and our assistance to Great Britain in United States parlance is now the theory of criminality that the Nuremberg Charter is based on. War crimes, battlefield crimes, soldier-on-soldier crimes, established through Hague Conventions and international compacts many, many decades earlier. Crimes against humanity, a new commitment, a new piece of parlance in international agreement, government against citizen criminality, separate from the war context, human rights violations at home, as within the jurisdiction of this tribunal, and conspiracy, the criminal coming together of the minds, the meeting of the minds, to engage in those 3 other crimes. And then they have to find evidence, identify defendants, and have a trial. Let me stop there, and I'd welcome some questions.
You mentioned something about the activities of
Right. The question is, what about the Japanese-American internment? Jackson is appointed to the Supreme Court in July of 1941. In the Department of Justice, during his 18 months as Attorney General, and before that as Solicitor General, there is counter-espionage, intelligence gathering, arrest, roundup, and internment planning that isn't small scale. It's quite significant. It is entirely about German-American Bundists and Italian-American fascist agents on our soil. There is no preparation in the Department of Justice. There is no policy making in the Department of Justice during Jackson's period for Japanese-American espionage, etc., national security threats. You get a frankly foolish assertion sometimes that they knew Pearl Harbor was coming, that Roosevelt wanted Pearl Harbor, they let it happen. One of the really strong pieces of refutation is how completely unprepared and disengaged they were from all issues Japanese, except the State Department channels with the imperial government. On the Supreme Court, Jackson as a justice is part of adjudicating the challenges to the Army policies beginning in 1942 after Pearl Harbor that resulted in first the curfews, and then the exclusions from coastal areas, and then the internment in camps of Japanese Americans. He is part of the 9 justices who unanimously uphold the curfew, and the decision it's a case called Hirabayashi. It's very explicitly limited to curfew, and it says this is, in the security context, a reasonable imposition of relatively small scale. Jackson, we know behind the scenes, was very uncomfortable with that, but he goes along. The next case, decided 2 years later, is the exclusion case called Korematsu, and Jackson is one of the 3 dissenters. He, along with Frank Murphy and Owen Roberts, said, curfew is as far as we go. This is incarceration, it is race-based, it's dragooning a civilian court process into a military measure. The Constitution doesn't permit us to be part of it. So that's where Jackson was on internment. He was only involved as a justice. Yes, sir?
I see a question regarding use of the term war crimes, particularly as it relates to the Holocaust. Usually the war crimes, you think of battle, soldiers. Holocaust deals with an evil that was perpetrated. So how does the Holocaust crimes come under the parlance of war crimes? And is it another category?
Right. We will cover that a bit in the next segment. But those 3 crimes in the London Agreement, waging aggressive war, war crimes, and crimes against humanity, in the 3rd category are talking about what we think of as Holocaust crimes. Army on civilian, government against population, either internal to a country or through conquering and occupation. And that's the theory on which ultimately the evidence comes in. But what's going on, I'm getting ahead of myself, during the Nuremberg trial is the discovery of the enormity of the Holocaust. And so the understanding we have of Holocaust, beginning with that word, beginning with genocide as an international commitment, develops coming out of Nuremberg. Isn't visible and clear and completely anticipated going into Nuremberg. But I'll continue on that topic. Yes, sir?
Was there ever any discussion of a legislative approval of these crimes, of the prohibition of these crimes, either in the U.S. Congress, the British Parliament, or the UN was formed about the fall of 45?
The UN is, no, it's the summer of 1945. It's San Francisco is May and June of 1945. Yes, but Nuremberg was ahead of it. So by December of 1946, the UN General Assembly has, as a general matter, endorsed the London Agreement and Charter and the Nuremberg Judgment. And then in subsequent years, the Genocide Convention by December of 1948, the Convention on International and Political Rights in 1949, and other human rights instruments are adopted and ratified first at the UN level and then as treaty commitments at the national level. It took the U.S. 40 years to ratify the Genocide Convention. The United States has only had war crimes legislation as a general matter, at least the stuff we're familiar with, the anti-torture laws and so forth, in the last decade. So national ratification trails this prosecution effort.
Wasn't that a legal problem?
It's not controversial in its time period, except in the context of assessing the justice of prosecuting the people in the courtroom. And so I will talk about that.
Along those lines, maybe later, you'd like to address,
Nuremberg becomes a part of the conversation. Nuremberg is a city in Bavaria. Bavaria was part of the American sector of occupation in Germany. During July, on the recommendation of the United States Army that Nuremberg be considered as a site for the trial, Jackson takes a delegation to inspect it. This is their airplane. Here's Jackson. Here's his British counterpart, David Fife, various other assistants who were part of his team, Frank Shea from Buffalo, New York, who was one of his principal legal advisors. They traveled to Nuremberg. Nuremberg, of course, is a city with great Nazi historical echoes. But that is a layer on the reasons to pick Nuremberg above the core reasons. That it was in the American sector, that it had a standing courthouse, more or less undamaged by Allied bombing, that connected to the courthouse was a large prison, were the reasons why it was suggested by the Army and why it was the British and American proposal. This is an aerial diagram map which shows you the Nazi Party rally grounds. This is one of the Nazi echoes. Beginning in 1933, every September, the Nazis in Hitler's survey would assemble and build and parade on this ground. There's a great road. There's a Zeppelin field with a reviewing platform. There are urns that burned with flame. You've seen Leni Riefenstahl's film. This great road, which connects to a structure called the Congress Hall and other things that weren't ever quite completed, points to the top of the old city in Nuremberg, where there is a castle. This is a recent photograph of the castle. It was one of the castles and palaces of the Holy Roman Emperor, a part of the First Reich. And one of the reasons Hitler and his theorists picked Nuremberg for the rallies and designed the rally grounds in that way was to connect visibly the Third Reich with the First Reich. This is what Jackson and his party found when they visited Nuremberg in July of 1945. Frauenkirche Church and the rest of the old city is smithereens, bombed heavily by the British in February of 1944 and again through 1945. Another angle on Frauenkirche. The courthouse, and from reading Nuremberg books, I frankly never understood this till I went there. The courthouse isn't in Nuremberg. That's why it was standing. The old city, the Altstadt, the formal classic Nuremberg, is connected, of course, it's sprawled a little bit today, quite a bit in suburban development, but the adjacent town is called Fürth. And the Fürthstrasse, the First Road, which connects Nuremberg to Fürth, about a mile away, has a palace of justice. And the bombers, through luck or precision, had obliterated the old city, but largely missed the courthouse. This is the signing of the London Agreement on August 8th. Jackson, British Lord Chancellor Jowett, French counterpart on his right. And this is the Palace of Justice that they found in Nuremberg. You see one section here is missing in the front of the building. I'll show you a modern photo at the end. That was the one place where a bomb hit. Shrapnel and collateral damage had largely obliterated the roof, and of course the facility had been trashed during the severe fighting that was part of the final German defeat and the Allies conquering Nuremberg in April of 1945. They picked this as their site. They rebuilt this as their facility. They moved personnel into this operation during the September-October period. And they began, this was a very American-dominated proceeding, they began to develop the theory of the case. The case was based on captured German records, a documentary case. That makes for boredom in the courtroom as one's reading and waiting for translators to translate captured German records. But the kind of records that were kept meant a case of that type was unimpeachable. There was no deal-making with cooperating witnesses. There were no battles of recollection. There was very little dispute about the authenticity of these documents. And thus, that was the kind of case they brought. They decided to bring the case, having lost the Hitler echelon, against representative individuals across the sectors of German culpability. 24 individuals plus 6 organizations, think of it as corporate prosecutions, were charged in the indictment. The indictment was drafted and presented to the tribunal in October, and within 6 weeks they were commencing this trial. This is the courtroom on the eve of the trial. You can see it's been enlarged. It's got a press gallery. It's got some seating into the back. It's got 4 prosecution tables, a judge's bench as you see it on the left, a defendant's dock as you see it on the right, defense counsel tables, court personnel, and off camera down here, a box where the translators would make 4 languages simultaneously available through the headphones and a dial system that was connected to each seat, so you could turn to your mother tongue. This is the actual start of the trial with the defendants in the box. You see the American table here, the Russian table, the British table, the French out in the cheap seats. You see the judge's bench. You don't actually see the judges. You see the defendants in the box. This is the American table with Robert Jackson at the front right corner. Thomas Dodd, who became his executive trial counsel, later a U.S. Senator from Connecticut. Senator Chris Dodd's father, here in the front left. Sidney Alderman, a great American railroad lawyer who Jackson brought as his principal deputy to London, who remained through the trial process. Whitney Harris behind Jackson, who is the surviving attorney, podium attorney from this trial, turning 97 next week, and other personnel. At the back of the table here is Jackson's son, William, age 26, a year out of Harvard Law School, born in Jamestown. He went as his dad's executive assistant. He was a little embarrassed that people would accuse his father of nepotism, and his father brushed it off and said, "Whose son am I supposed to take?" These are the defendants in the box. Film was slow, so the MP is word. Hermann Goering, Rudolf Hess, Joseph von Ribbentrop, etc., Albert Speer, other prominent names. There were 21 individuals who were treated as alive and prosecuted in this case. One had committed suicide, one had absconded, etc. So 24 is down to 21. And one of them was being tried in absentia, Martin Bormann, who turned out to be dead. So there are actually 20 who are in the box. The trial begins. This is a close-up of the Goering corner. He's defendant number 1. The trial begins with the reading of indictment on November 20th, and then with Jackson's opening statement on November 21st. It defies performance, I assure you, but it's one of the most eloquent, powerful speeches ever delivered in English. That 4 great nations, stung with injury, stay the hand of vengeance, and submit their captured enemies to the judgment of the law is one of the greatest tributes that power has ever paid to reason, argued Jackson. It's the Morgenthau vision, it's the Truman decision, it's the Roosevelt commitment. Stimson, not Morgenthau. And it is something that is being done for the first time. War had been something that nations did as a matter of prerogative. And at the end, somebody prevailed and somebody was vanquished. Thus, the winner had more territory and resources, and the loser slunk off with less territory to do whatever, rebuild, come back, fight again. War was not illegal. And to the extent there were crimes that could be committed in war, they were battlefield crimes. They were soldier crimes. They were shooting rather than taking into custody a prisoner of war. But they weren't leadership crimes. What Nuremberg is doing is treating the war itself as a crime and holding heads of state accountable. Jackson arguing to the tribunal. Jackson in his office. This case turned out to be very hard, very complicated, and medium successful by the ultimate measure one assesses criminal cases. Everyone was not convicted. You might say, oh, what a terrible setback. And actually, in the moment of those acquittals, on September 30th, 3 acquittals, 18 convictions, Robert Jackson felt, as any prosecutor does, that he'd carried his burden of proof and that the court had blown it and that he was entitled to convictions. With very little reflection, Jackson came to understand that those acquittals, almost more than those convictions, proved the legality of the process. This was not a rigged trial. This was not a show trial. These were not foreordained convictions. The 3 acquitted Germans kind of looked at each other stunned when the tribunal delivered the news, asked their lawyers what they were supposed to do. The lawyers asked the guards. The guards said, I don't know, leave. And so they walked down to the front door of the courthouse where they found irate Germans assembled to lynch them, and came back into the countries that had tried them to ask if they could have their cells back that night and protective custody. A real trial is a trial where the prosecution doesn't run the judiciary. And Nuremberg was such a trial. The bench was independent. A real trial has a burden of proof. The American standard, proof beyond a reasonable doubt, is what Nuremberg adopted. A real trial, due process, occurs in public. That's what Nuremberg was. Every day, that gallery that you saw in the photograph is filled with reporters. It got boring. It was documentary. It was reading. It was slow. But it was entirely transparent. A real trial has skilled defense attorneys fighting on their client's behalf. These 20 Germans who were on trial, plus the 6 organizations, had the right to select counsel, and they all did. And many of them selected the giants of the Nazi bar, unreconstructed leaders of legal Germany under Hitler. They were given office space, they were given housing, they were given financial resources for staff and investigation, etc. They were given mimeograph copies of everything they asked for. They were given interrogation records. They were allowed to defend their clients. The tribunal was extremely generous in letting the defendants testify freely. The rules of evidence were loose and permissive. The times allocated for opening and closing arguments, the ability to call witnesses, all very expansive. And over the course of this year, the Allies, led by the Americans, make a case of who had decided to wage this aggressive war, who had commanded, known of, or tolerated the battlefield atrocities, and who had devised and played roles in a system that involved dispossession, relocation, cruel incarceration, and extermination of enemies of the state, largely German Jews. What they found is that that idea of the human rights crime was under-inclusive. They came to understand the camps in the East, not German Jews, Polish Jews, Russian Jews, etc. And not concentration camps, but extermination camps. The maps that were used at the start of the trial have obscure dots and some names to the camps in the East. But the camps they knew, Sachsenhausen, Dachau, etc., were the German camps. That Auschwitz thing, that Sobibor thing, that Belzec thing, those were known but unknown. Late in the trial, one piece of the development that I think crystallizes this is one of the defense attorneys seeking a newly captured witness. This fellow's name is Rudolf Höss. He had been the commandant of Auschwitz for 2.5 years. Kaltenbrunner, the defendant, the head of the Gestapo, heard that he'd been captured by the British, wanted him transported to Nuremberg, wanted him as a defense witness. Why would a defendant want the commandant of Auschwitz? To say that Kaltenbrunner never visited Auschwitz. And so Höss was brought, and Höss so testified. And on cross-examination, the Allies, led by American interrogator and prosecutor John Amen, elicited the testimony from Höss about the numbers and the systematic extermination that was Auschwitz during his period of administration. 2.5 million was Höss's number. Puffing and bragging a little bit is what historians have concluded. But it was his assignment, and he carried it out, and he'd been loyal to the Fuhrer, and he was unapologetic. That's an example of the record that Nuremberg built, and an example of the knowledge that the world acquired through this trial process. At the end, in the fall of 1946, Jackson returns to the Supreme Court, and he recommends to Harry Truman that there be no further international trials. The Cold War had started during that year. It in part had started during that trial in that courtroom. And the Soviet understanding and commitment to due process and a Western model of law never really took. What could be continued, Jackson argued, was prosecutions at the national level, in the sectors of occupation in Germany, in homeland areas where crimes had been perpetrated. And so there were Russian sector and British sector, even French sector and American sector trials. Nuremberg being in the American sector meant that the national trials included 12 subsequent Nuremberg proceedings. This is Jackson with his deputy, Telford Taylor, who took on the assignment of leading those 12 subsequent proceedings. And those trials carried through 60 years ago today, 1949. They went a layer deeper than the representational defendants and prosecutions that had been part of the international trial. And thus the doctors and the justice system and the Nazi high command, etc., were these cases. One individual, Otto Ohlendorf, who it came to be understood during the first trial where he was a witness, deserved individual prosecution. Another individual, it came to be understood during that first international trial, also deserved individual prosecution. His name is in documents. It starts to be mentioned during the trial. He was a fugitive, and so this fellow, Adolf Eichmann, is not part of a Nuremberg trial ever. He's captured. He's brought to Israel. He's prosecuted in 1961. And although the territory is different and the legal apparatus is different, I think it's fair to think of Justice Bach and his colleagues prosecuting Eichmann in Israel as a national trial as one of the Nuremberg subsequent proceedings and building on Nuremberg's precedent. Let me stop there to conclude phase 2, and I would welcome some questions before we talk about the legacy of Nuremberg. Yes, ma'am?
Could you comment on the opposition of people like Senator Taft to the whole process?
Would you like me to be flippant or to credit his arguments? My flippant answer is that Bob Taft expected to run against Bob Jackson for president in 1948. And so when Jackson returns from Nuremberg, Taft, in an effort to begin to dirty up Jackson, attacks Nuremberg. That's my flippant answer, although it's true. Taft's argument is that Nuremberg was illegal, that it invented law after the fact, ex post facto, and prosecuted people for doing things that were legal at the time they did it. He also argued that it was victor's justice for the Allies, having defeated Germany, to then bring them to a courtroom and subject them to our law. The answers to those arguments are for you to assess. In terms of the ex post facto critique, the Jackson argument at London, at Nuremberg, and in the speeches and articles that were part of the remaining 8 years of his life, was to ask, in what civilization, in what culture, has murder ever been a licensed and permitted behavior? In what society has a brazen attack for pure aggression ever been a laudable endeavor? You look at religious documents like the Bible, the Quran, any holy book, you find prescriptions on human rights abuses. You look at compacts that the international community, including Nazi Germany, had subscribed to in the 1930s, and the German Weimar Republic before that, such as the Kellogg-Briand Pact, that had evolved to the direction of condemning aggressive war. We had never enforced it, said Jackson, but we had long been committed to it. The rules were known, the crimes existed, what we simply brought was the authorities. As to victor's justice, us being the conquerors, imposing this on the vanquished, Jackson said, who else was there to do the job? There was no Germany. There was no international apparatus other than this one that the world community created. And by the way, it wasn't just the 4 nations who were the participants. The London Agreement was subscribed to by 24 other countries at its time, and then adopted by the United Nations, which in 46 is about 45 countries. So the world endorsed this and was part of this. And the alternative to the victors doing it in that setting where there's nobody else is to let them go, or perhaps to line them up and shoot them. And as between those alternatives, Jackson was very comfortable defending the path they took. Yes, sir.
What I don't understand is at the Nuremberg trial,